Welcome to the Executive Compensation Podcast. I'm your host, Ryan Harvey. On this episode, I'm joined by Darren Moskovitz. Darren is a partner at Meridian working out of our New York office. Darren, welcome to the podcast.
Ryan, it's great to be here. Thanks for having me.
Yeah, thank you. So what happens to an executive's compensation arrangements when they leave a company? Whether the executive leaves voluntarily or involuntarily, this is a fundamental governance question every company must consider. How are annual and long-term incentives treated? Should the individual receive cash severance? For many companies, the answers to these questions have been influenced by restrictive covenants, such as restrictions against working for a competitor or restrictions against soliciting clients and employees. The FTC has recently issued rules that would essentially eliminate non-compete restrictions going forward. And if these rules stand, they'll likely alter how many companies approach the departure of an executive. So today we want to explore severance approaches and then discuss how the elimination of non-competes could potentially change that landscape. So Darren, I want to spend some time talking about just that. I want to talk about the elimination of non-compete restrictions in particular and how that might impact, executive departures and severance. But before we get into that more recent development, I wanted to just spend a few minutes talking about just general practices in particular as they relate to severance practices. So maybe you can just give our listeners a little bit of an overview. What are typical severance approaches? Maybe distinguish between general severance and change of control severance practices, and just what are some of the basic reasons why companies put those practices in place?
Yeah, Ryan, thank you. And I think it's probably best, let's start with your last point first, and the fundamental principle about why companies actually have severance plans and policies to exist with, because I think that will set a foundation for maybe the future of the rest of the conversation. I think you hit on it a little bit to begin with. Look, I think there is reputational reasons and there are commercial reasons why organizations put severance policies in place. One, it's pure competitive market practice. But two, as we think about attraction and retention of executives or just the broad-based population in general, there is clearly reputational concerns. Do we have that program in place to attract talent to our organizations? And then more broadly, are we doing the right thing on behalf of the individuals as they might leave an organization for a situation that we might deem to be outside of their control? So are we going through a reduction in force, or are we going through a particular transactions? Organizations have taken the position that we want to do right by those employees as we go through those particular events. Yep. That sits more on the reputational side. The commercial reason why organizations have severance plans and practices in place is tied to how you led the conversation around making sure the organization has the right protections in place as individuals leave an organization. So we talk a lot about maintaining or owning sort of our intellectual capital. And these severance programs in some way, shape, or form, Ryan, are simply just contracts or agreements between the company and the individual that if I am willing to help you with your transition, you won't compete with me or take my talent or take my customers as we go through this journey. So think of it as sort of a contract or an agreement between the individual and the company as they go through this transition.
Yeah, and there's different schools of thought between the advantages and disadvantages of having everything spelled out in advance, having whether they be contracts or severance plans. And then, of course, there's just the purely ad hoc approach of, if an executive leaves, we'll negotiate something when they leave. It sounds like you're probably falling more in the camp of having things documented up front. Makes sense?
I think there's certainly, I'll say, some best practices when we're thinking about severance plan. And we could say like having a severance policy to begin with, could fall under the umbrella of a best practice. But most organizations, just from a prevalence perspective, Ryan, and how they do this, whether they do it through a contract or whether they do it through a severance plan, will have the terms of that severance plan written in some way, shape, or form. So what am I willing to pay when I leave the organization? And literally, that is just a finance exercise. What can I afford to pay a certain individual or a certain groups of individuals if I'm going to go through a reduction of force or eliminate a role or go through a potential transaction. And companies generally want to know what that cost is upfront. And that to me is just good financial discipline.
Hmm. Yeah.
Yeah.
And maybe just one other just quick nuance, and then I want to get into the whole non-compete development. But
Yeah.
there's these two categories. There's general severance, which is severance in just kind of normal course, somebody is involuntarily terminated. And then very often companies have special provisions that only kick in if there's a change of control, a merger event or something that somebody loses their employment through that event. Why the distinction? Is there something unique why there should be some sort of a distinction there?
Well, I think the history is really important here. If we can go back, we'd almost have to go back to the 1980s, Ryan, and understand why that distinction even occurred in the first place. So let's go back to, depending upon how old you are, we could remember sort of a movie called Barbarians at the Gate, but that movie is sort of surrounded around the concept of when leverage buyouts started to become really prevalent in the market. And we saw the use of debt to acquire companies. Prior to that, Ryan, we effectively had one form of severance. If I, as the company, made a decision to involuntarily terminate you for whatever the reason may be, either I don't want that role anymore, or I prefer to have some other individual in that seat rather than him or her, there were severance practices that were put into place, and they were largely at the executive level. They largely sat at a range of sort of 1 times or 2 times your current annual compensation. So think about base salary plus your target bonus. And that's what organizations were willing to do to help bridge you to your next role, to address some of those points that I talked about earlier. Suddenly the LBO concept comes into place, and there's a view that executives want some incremental protection because there was a chance that, there would be forces that would force a deal or force some sort of transaction on an executive leadership team where they would likely lose their role. So at that time, the industry sort of evolved to create this enhanced or CIC, change of control severance concept. And then we saw basically those multiples increase, Brian. So they basically went from the 1 to 2 times that I shared with you to almost a 2 times to a 3 times multiple, because the view was it wasn't the executive making those decisions. It was some external forces coming to buy the company that led us to lead to some of those enhanced levels. There's other considerations as well. So how to handle equity on an involuntary scenario versus a change of control scenario. Organizations tend to be a little bit more generous on the equity treatment on a CIC basis, largely along the view of the shareholders have won on this deal as well. Why not have the executive share in that participation as well? But there's a series of things that I would say every organization has to sit down and say, what are the elements of compensation? What are the ways in which an individual might leave an organization, inclusive of voluntary termination, involuntary termination, a potential transaction? And then based upon those different pay elements, how do I want to treat them under those specific scenarios?
Yeah. 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 And I think, what you're alluding to there in that change of control situation you were outlining is there's just this inherent, at least potential for a conflict of interest of, the executive is at least either pursuing or at least allowing a deal to unfold that they know could potentially put them out of work. And therefore you could argue maybe a slight enhancement to severance over a normal involuntary termination where they have there's nothing on their part that's going to influence the termination. They're not pursuing an action that's going to lead to their
and really the principle on why I think committees have gotten comfortable with that enhanced level, Ryan, is they want to avoid disruption in the business operations. So if the true principle of the committee and the board is to do the right thing on behalf of the shareholders, the view is if those deals come across the table, we want our leadership team to be thinking about the broader shareholder base and making sure we're doing the right things on behalf of our shareholders versus their particular self-interest in that specific situation. So we've sort of, industry practice has evolved to almost make this enhancement upon a change of control to sort of be market standard.
Yeah. Yeah. Okay. Well, let's shift now to the really the kind of the current events of the day that might influence some of these things we just talked about, and that's the Federal Trade Commission. So essentially banned non-compete provisions, and I know you can walk us through that, but maybe we just start right there. If you can just walk us through a little bit of the kind of the recent current events, what has the Federal Trade Commission done, and how is that going to impact specifically non-compete provision?
Yeah. Well, let's start with sort of a foundational statement like non-competes are not new. So
Mhm.
the question that we have to ask ourselves is what has fundamentally changed that all of a sudden the Federal Trade Commission, or I'll refer to it as the FTC going forward, has taken a new position on these provisions. And I think the fundamental thing that's changed, we have to go back to about 2021 when Lena Khan was appointed as the FTC chair. She's extremely young. So she graduated from law school in 2018. That's only 6 years ago. President Biden appointed her to the FTC, and then she was almost unexpectedly named the chair shortly thereafter. So she sort of had this mediocre rise to running this organization. But how Lena sort of rose in prominence is while she was at law school, she sort of criticized antitrust enforcement in a paper that she wrote. And she took the position that the current model that we've established to address market forces in the digital economy just isn't fit for purpose. So anyone that has been following her or following the FTC, she has tried, maybe we could say, and not been successful to file lawsuits against some pretty high profile mergers and some pretty high profile organizations. Ones that I think we'll know off the top of our head is she has sued Amazon for taking a position that they maintain monopolistic practices. She put a lawsuit to resist the Microsoft Activision merger, and Activision is the creator of Call of Duty, and her position there was there's just too much data that Microsoft would have at their fingertips. So she's been a real proponent of sort of resisting against these large mega mergers, but her position has been one, that they result in a reduced workforce, but two, she's also taken the view that it stagnates worker pay and it's not good for just the overall public good. So I think that background is important because Mrs. Khan has taken the position then that these non-compete provisions actually do that. They limit the abilities for workers to move freely in a capitalist society, and she says it actually hampers or restricts worker pay because they cannot act in a sort of a free competitive market. So that's a bit of the background about why this came about and why it came about now. So it's a relatively new concept, and Mrs. Khan is really pushing the edge on what we would say is sort of like settled case law, that these provisions have been acceptable to some extent historically, although there is some state by state variation on where they are allowed.
Yeah.
But basically what she is saying, or what the FTC is saying, is that these non-compete provisions are unfair methods of competition and they just shouldn't exist. So there's the pure non-compete, but there's things that are tangentially connected to it, Ryan. So the concepts of non-solicitations of employees and clients. For someone who's running a sales organization, I think Mrs. Khan would view that as a form of a non-compete. And what she is saying is we just shouldn't have these, we shouldn't allow these provisions in the markets in which the FTC has oversight.
And so these rules essentially, I mean, I know there's some grandfathering of existing, non-competes, but in general, if these rules stand as they're currently written, they essentially eliminate non-competes across the board. Is that?
Yeah, that's right. That's right, Ryan. And there's different industries that utilize these non-competes more heavily than others. Like the principle is really, from the firm's perspective, is we want to protect our intellectual capital. And we at least want some time for people to forget, what was the code that we drafted, or what were what was the way that we were going to market. So that time frame away from the firm or separated the firm was a way for them to protect their interests. But what Mrs. Khan is saying is, going forward, with a very small exception for, the most senior executive officers at an organization, these non-competes would not be allowed.
Yeah. Yeah. And also this is somewhat new territory from my understanding for the FTC, that they've historically been much more of an enforcement agency, not so much a body that issues regulations. And this really is kind of new ground for them, which I guess is one of the things that will be tested in the courts is, do they have the authority to actually issue regulations, not simply, enforcing current regulations.
It's a great point. And there's just been many people that have said this is a broad overreach of the FTC's powers. So, and as expected, we have seen some bodies say, look, we're going to challenge this in court, and that process is already underway. But I think we're at a time, because it's suddenly in front of us, that firms need to start thinking about what to do next if it goes forward, and start to inventory things and give considerations around next steps.
Yeah. So let's move into back into the world of executive pay.
Yeah.
So, we started out, we talked about the fact that, companies do a lot of thinking and planning around what happens in a departure of an executive. Many of those, severance structures have been closely linked with non-competes, but also non-competes very often are kind of linked with other aspects of executive pay. So maybe two things. First of all, what might this mean just in general to executive comp programs? And then maybe we dive in specifically to, departure-related, severance-related programs, and how, if this stands as currently written, how that might impact some of those programs.
Yeah, sure. Ryan, past is a predictor of the future. So if we believe that, and we look back in time at any time sort of new regulation has been implemented, we've sort of seen the market react to that regulation. And it has generally led to, I'm going to say, increased compensation, or a change in the way that we think about compensation. So now presents an opportune time to at least put our crystal ball on and say, well, what do we think is going to change? And even going back, there's a whole series of things we can look at, whether it's the Deficit Reduction Act of 1984, when basically the IRS introduced 280G and 499 of the Internal Revenue Code. We had the invention of excise tax gross ups. When the SEC implemented their new disclosure rule, where suddenly we have this huge amount of transparency in executive compensation, suddenly everybody knew what everybody else was getting paid. I think we could go back and run the correlation analyses and see there's actually a relationship related to, when these regulations were put into place, and how the executive compensation changed generally more favorably. So the one thing I think that we will likely see is we will see compensation increases as talent can move more freely through the markets. I think we will see the requirement to have a competitive market level of compensation will just be upscaled. So I think Lena Khan, in her interest, or what she put forward, thinking about the broader American worker, I think it makes a lot of sense. You would say, look, I'm really focused on compensation at the broad scope of the organization. But I think the principle we have to ask ourselves is, who had these non-compete provisions to begin with? And I can make the argument they generally skewed towards higher paying industries. They generally skewed towards higher paying roles. And we might see some of those roles continue to uptick in pay levels, as there's very few barriers for them to move from company A to company B.
Yeah.
I think the other thing we'll see is companies are just going to need to rethink about how we think about severance.
Yeah.
Going back to my original premise, Ryan, of why severance was put in the first place, and what were the commercial reasons that we have it, on how we're protecting the organization. We've seen these, we've seen these multiples range from about 1 times base and bonus all the way up to 3 times base and bonus under a change of control scenario. There's been a lot of pressure from institutional asset managers and shareholder advisory groups just to bring down those multiples over time, because in some way they had a view that they were probably too rich. I think firms did the calculus to say, look, we are getting a benefit in this because people that know our organization best will at least be on the sidelines for a specific period of time. That cost benefit analysis naturally changes when in any severance scenario, an executive can be terminated on a Tuesday and go work for their number one competitor on a Wednesday. So the value that we're associating with those severance multiples, if this goes through, Ryan, I think naturally over time, we might see those multiples start to come down. So
Yeah. Yeah. Are there any ways that we, a company could still protect themselves in some way and provide severance?
yeah,
Um,
I think there is, and there's some unique ideas on that front, and we could talk through those things. I think there's probably one more thing to just talk about before I hit on that point.
yeah.
And I think this is important. Look, when we went through that, like I shared with you, that leverage buyout market, and a lot of transactions went through, and a lot of executives are receiving these big severance packages, the government stepped in and basically enforced a tax on sort of the benefits of the compensation received associated with that particular transaction.
Yeah.
Those of us that are compensation experts refer to this as an excise tax or a 280G tax. One of the things that the non-compete provisions have allowed us to do over time, Ryan, is they've allowed us to say, look, there is reasonable compensation associated with that particular executive sitting out a certain period because they can't go get a job. So it's allowed us to effectively lower the tax implication associated with the 280G excise tax. And that's been something a lot of organizations have relied on to mitigate their tax expense, which is really a tax expense to the individual.
Yeah.
That will go away effectively, with this legislation. So, there's a whole series of, beyond just the severance multiple, Ryan, like there is things related to the change in control provisions that I think everyone will stop and take a look at when we run the numbers to say, what makes most sense for us as a firm and what makes most sense for us, as the ability to attract and retain compensation talent. I'm not saying gross ups of excise tax will return to the table, but I imagine it will be a discussion that we have not had in a really, really long time.
Yeah.
On your question related to like, what can we do and what else might we see? And this is where maybe we can look across the pond to learn a little bit about how some of these practices have evolved. The FTC in their final rule did clarify that garden leave arrangements might likely be outside of the reach of what they put into place. And garden leave arrangements, right, it's a British term, but for all intents and purposes, it's effectively you're paying people to sit in their garden for a sustained period of time. And this is a practice that we see more in banking and financial services. But the idea is whether you leave voluntarily or whether you leave involuntarily, I will require some sort of notice period based upon your level of the organization for you to leave. And that notice will be reciprocal. Like I'll provide it to you as a employer and you will provide it to me as an employee when you leave. And then basically during that garden leave period, I will continue to pay you your compensation. So you will still technically be an employee of the company, whether you're in the office or not, might be firm specific circumstances. But this is something that we do see in some industries, in some geographic locations that could increase in prevalence here in the United States. The big challenge with this, Ryan, it's really expensive. So, we're talking about, in some cases, applying this broadly across the company and then, continuing someone's salary, benefits, and potentially incentive compensation, equity vesting for, 3, 6, 9, 12 months, depending upon the terms of the garden leave. But I think that will be a natural sort of direction that people go, particularly because the FTC already said it's likely acceptable.
Yeah. And the garden leave, I mean, so it's helpful in, I guess, one sense, in the fact that it's going to at least help you avoid a situation where you're paying severance to somebody who's actually directly competing with you, which would kind of sting a bit if that were to occur. So at least with the garden leave, if they're getting paid under garden leave, they're still technically your employee, and so they're
Yep.
not competing. But what it doesn't do is, I guess if there's a big enough carrot out there from your competitor, you could the executive could always say, well, I'll just forego the garden leave. I'm going to go compete with you. So it doesn't necessarily stop them from competing, but it does
Yep.
stop them from taking your money and competing, which
Yeah.
I guess is good.
I think the key thing, the key step in the process is um, implementing a policy where you could mutually agree that there should be some notice period. And, for a new employee that you're attracting to the organization, that's fine. But for all your current employees that maybe had, non-compete provisions in place that tomorrow might not exist, and you suddenly want to implement this notice period concept, like clearly there would have to be consideration in place to get someone to sign that notice period, which again goes to my point about, anything here is likely to be, there's a financial consideration to anything we're going to be implementing related to garden.
What about some of the other restrictions we see? So there's, intellectual property, and there's non-solicitation of employees or clients. Do we think, those are still allowed? Do we think those will be altered at all or strengthened if the non-competes go away?
What's really interesting is the language from the FTC was so broad that I think the answer is we don't know. Right. And they probably have some work to do to be a little bit more explicit and detailed as to what will be acceptable and what won't be acceptable. If you read the black and white of the regulation, you could easily make the conclusion that non-solicitation also might not fit under, might not be allowed. It might be more role specific. So do I have sales? Am I running a sales organization, or am I a sales individual? And does that hamper my ability to compete maybe versus someone who's in the corporate function? So we might start to see some variation by role type as to where a non-solicitation of clients might be allowed. I think we'll still see non-solicitation of employees. Like there's nothing in there that says I'm hampering your ability to compete. We'll still see non-disparagements. We'll still see confidentiality. But I would say those are the more low-hanging fruit items, Ryan, than actually protecting the commercial interest of the organization, where that's really where non-compete provisions and non-solicitation of client provisions exist.
Yep. Interesting things to anticipate here. And, you alluded to it earlier, that there's always that law of unintended consequences with any time you try to regulate something, and it will be, I'm sure there's things we can't even anticipate how they might be impacted. But I know, just even kind of thinking from a broad-based perspective and beyond executives, so many of these different professions where there are non-competes, they're professions where you're bringing somebody in and doing a lot of training earlier in their career and making a lot of investments in them, kind of for the trade-off for them to agree not to compete. So it'll be interesting to see how that employment relationship is altered if now, I'm training, investing in someone who could compete. Who knows the impact, but it definitely would have some sort of an impact. So it'll be interesting to see.
We don't know.
Yeah.
We don't know, but I do know this, like it will look different than if this goes through. Things will evolve and things will look different, a year from now, if this gets put into place than they do today. And committees will start having conversations, like I said, that we haven't had in a long time related to these types of plan provisions and these types of design provisions.
Yep. So maybe just to kind of close out. So, as you mentioned earlier, these rules are currently being litigated. We'll likely hear some early findings from the court, in the next couple months, but who knows, it could be many months after that before we get any kind of final word as to the status of the rules. But in the near term, what should companies be doing? Are there any immediate next steps that should be taking, or is it more of just a wait and see approach at this point?
Well, I'm not a big wait and see guy. So that hope is not a strategy, as they say. I will share for the listeners that the U.S. Chamber of Commerce, along with other business interests, did file a suit against the FTC. So that is in place.
Mhm.
They're looking to bar the implementation of this non-compete ban. They said the FTC overreached their authority. They're doing this in Texas, which generally tends to be more favorable to the business, to business in general. The word is that we're probably going to have some resolution around this by July 3rd. So happy July 4th to everybody in the U.S. I also think, Ryan, like the presidential election will just cast a shadow over all things executive compensation over the next 11 months or as we work towards November. So that will have an impact, and will have an impact on Khan's tenure. So if Biden wins, she likely stays in her seat. If Trump wins, assuming these two gentlemen are the candidates, it's likely she will no longer be leading the FTC. So there's a lot of variables, I think, over the next couple of months that will come into play. All that being said, I don't think it's too early to at least start discussing it, at least start understanding what my severance plans are today, doing some inventory around what sort of non-compete provisions that I have in place, who will be impacted, who won't be impacted. And then it doesn't hurt to start considering potential alternatives. It's never too early to start planning on those things. I would say don't do anything yet, but at least putting in the work will, when something does happen, if it does happen, will just make the transition a little bit more thought out and a little bit more seamless. I like saying I don't want to be held to a gun at a particular time to make any decision. I want to have time to make those decisions when I have a clear mind and I'm not biased by speed or judgment.
Yep. Yep. No, good thoughts. And like you said, always good to start planning for any potential, possibilities, and make sure that you're prepared, because if things do stand as currently written, we may have to react pretty quickly. So
That's right. That's right.
Well, thanks, Darren. Again, thanks for joining the podcast. I think this has been a really interesting conversation about some pertinent, current events and how those might impact executive pay. So thanks again.
All right. Thanks for having me. Always a pleasure.